Good evening to you all and welcome to the course on Law of Sea and Maritime Law. We start the discussion again. This is week 2, lecture 5. So yesterday we have discussed up till the criminal jurisdiction of the coastal state. Criminal jurisdiction that the coastal state can apply to any of the ship that has entered closer to its territorial waters, and when it finds that some crime has been committed, so to what extent the coastal state does have the criminal jurisdiction. What are the limitations to that criminal jurisdiction that we have already discussed. Today we discuss the civil jurisdiction in relation to foreign ships. So foreign ships, I would like to remind again, they are the ships that are registered in the foreign country, not in the coastal country about which we are talking. And they are carrying the flag of the country where they are registered. For example, let's say if the ship is registered in United Kingdom, so that ship will carry the flag of United Kingdom, and when it reaches the Indian waters, India will be the coastal state and the ship will be considered as the foreign vessel or the foreign ship. And the law will be in general, as per the international law, the law will be applied to that of the flag state, that is where the ship is registered. But only in certain conditions the law of the coastal states will be applicable. So we divide this with regard to the criminal jurisdiction, that is on what basis the law of the coastal states with regard to the criminal law will be applicable, and on what grounds the civil law or the civil jurisdiction of the coastal state will be applicable. So today we start with the civil jurisdiction. The coastal state should not stop or divert a foreign ship passing through the territorial sea to exercise civil jurisdiction about a person on board the ship. One more thing I would like to add here, civil jurisdiction is further divided in two categories. One is the continental European system of the civil law, and then another is the common law system. So to a great extent they also apply their own interpretation, despite the fact that there is the common international law principle under the unique laws. So that is one such one overarching kind of rule. But sometimes the coastal states, they may apply their own jurisdiction with regard to the civil matters, depending upon whether they are from the common law countries or they are from the civil law countries. So here the coastal state should not stop or divert the foreign ship passing through the territorial sea to exercise civil jurisdiction about a person on board. In case like if a person, although when we talk about the territorial sea area, there is a sovereign right over that territorial waters of the coastal state. When we say that there is a sovereign right of the coastal state, that means all the laws that the coastal state does apply to its land boundary or up till the land boundary, the same laws will be applicable also to the territorial waters. Now, when a ship, that is the foreign ship, has entered its territorial waters, and there, whether the ship can be stopped for applying the civil jurisdiction, for applying civil jurisdiction because of someone who is sitting inside the ship, and that person, there is a civil matter pending before the court in that coastal state. So whether the ship can be stopped just to make that person liable before the court, or to bring that person before that court, or to issue the summons for that court. So here I would also like to add, it varies depending upon the legal culture. For example, one situation is that where ship has entered the territorial waters and is not going to halt in any port of that coastal state. So in that case, they cannot give any warrant, they cannot issue summons, they cannot pass any order, or if already an order has been passed, they cannot give the copy of that order to the person who is sitting inside the ship or who is on board and traveling through that ship to some other country. So that is one situation. In second situation, if the ship has entered the port, is anchored, or that means the ship has halted in that port and it is a common law country. In that case, and there is a matter pending before that person who is on board, and a decree has been passed or the summons are issued. So in that case, the court can direct that this person, when sitting inside the ship or is on board, he can be given those summons or the copy of those summons, or anyway he can be made aware that there are some matters pending before him in the court. So that to that extent, the common law countries allow the notice to be given or that person be informed that there are some court proceedings going on in that coastal state. But not that they will, if the ship is passing through, they will halt the ship or they will try to arrest that person. It's not like that. The coastal state should not stop or divert a foreign ship passing through the territorial sea to exercise civil jurisdiction about a person on board the ship. The coastal state may not levy execution against or arrest the ship for any civil proceeding, save only in respect of obligations or liabilities assumed or incurred by the ship itself in the course or for its voyage through the waters of the coastal state. So the second condition state that the coastal state may not levy execution against or arrest the ship. So because of any civil matter, no such execution will be done, as I stated to you, that they can simply give the notice. They can give the copy of the notice that there is something pending against that person, against that ship before the court. So to that extent, it's possible. But not that they will not allow the movement of the ship until unless the ship has completely absolved that matter, or it has shown someone representing the ship has shown its presence in the court, and then only the ship will be released, or the ship will be allowed to further move from that country or from that territorial waters. It's not that rigid. But in some cases, it can be rigid. For example, if there are liabilities pending before the court and there is something which is of the nature of mortgage, or the ship was mortgaged, or some property in the ship that is mortgage, or part of the ship is mortgage in that coastal area or in that coastal land, so and decree has been passed against that ship, or something as a surety was kept by the owner of the ship with regard to the ship itself, or maybe for repairing the ship, or a loan has been taken giving the ship as in terms as mortgage. So then the status may change. So then we cannot say that the court will not take strict action. So in such cases, when there are liabilities incurred of such nature or obligations incurred on such nature, then they may not allow the ship to pass through the territorial waters until unless those obligations are met or those liabilities they are absolved. So that is what the second point states. The coastal state may not levy execution against or arrest the ship for any civil proceedings, save only in respect of obligations or liabilities assumed or incurred by the ship itself in the course or for its voyage through the waters of the coastal state. So if the ship has itself given part of it as a surety, or has taken loan, or maybe some other encumbrances are pending. So in that cases, the ship has to fulfill those obligations or those conditions that are set. Paragraph 2 is without prejudice to the right of the coastal state in accordance with its laws to levy execution against or to arrest for the purpose of any civil proceedings a foreign ship lying in the territorial sea or passing through the territorial sea after leaving internal waters. So if the ship has already entered the internal waters and now it has reached the territorial sea, but the moment it has reached the territorial sea, something seems to be found, or it seems that there is some civil liability pending, or the civil proceedings that were going on, an order has been passed against that civil proceeding. I repeat this. Now there is a situation when the ship has entered the internal waters of the coastal state, and after entering into the internal waters, it has now started taking its journey again, further journey in continuation of the previous journey. So that means after internal waters, it will reach the territorial waters. So at the time it has reached the territorial waters, something has been decided by the court. So in execution of that, the order that has been passed by the court and ship, the status of the ship is that it's still in the territorial water. So in that case, it can be apprehended, or there can be execution or arrest of that ship. So paragraph 2 is without prejudice to the right, because the coastal state does have the right. Prejudice to the right of the coastal states in accordance with its laws to levy execution against or to arrest for the purpose of any civil proceedings a foreign ship lying in the territorial sea or passing through the territorial sea after leaving internal waters. Now it could be because when the ship entered into the internal waters, it has done some damage, or let's say it has incurred certain obligations, so that has to be fulfilled before it leaves the coastal state. So in order to fulfill those obligations or to make it binding, the right has been given to the coastal state that it's up to their discretion or their legal discretion whether they allow the ship to pass through the territorial waters once it has reached the internal water. So this condition is not applicable if the ship never entered the internal waters. It is only applicable once the ship entered the internal waters and then it is leaving through the territorial waters. Civil jurisdiction, although jurisdiction in civil matters is enforced in the last resort by the application of sanctions of criminal law, but there are a number of differences. So usually what happens when number of times the person has been asked to fulfill its obligations, the civil obligations or any such matter of civil nature that is pending before the court, and the court has passed a judgment, issued the order or has passed the decree and the person still is not complying. So later on, after repeated reminders from the court or repeated order being passed by the court, that may later on turn into the criminal punishment. Why it is so? Because then the court has to take the strict measures. That criminal punishment means because then the person can be imprisoned also. So here we need to distinguish. The distinction is that in case of the criminal matters, that's the punishment of first instance, that the person will be arrested. That's very likely that the person will be arrested. But in the matters related to civil wrong or when there is a question of rights of such nature that leads to the obligations of the civil nature or the commercial nature. So in that case, it's not the first step that there will be criminal sanctions based on the criminal law or the person will be given some criminal punishment that are usually given for the crime committed. But that will be the later part. If repeatedly the person has not complied with the punishment or the fine that is imposed or the remedies that are as a consequence of that civil proceedings. It is fair to say that the exercise of civil jurisdiction has been claimed by the states upon far wider ground. In common law countries such as United States and Britain, the usual basis for jurisdiction in civil cases remains service of writ upon defendant within the country, even if the presence of the defendant is purely temporary and coincidental. Now, here when we say the service of writ upon defendant within the country, the example is what I just gave to you. And I repeat this example here. Like I said that take the example that someone who is on board the ship and he started his journey from London. Okay, from London he's on board the ship and final destination is, let's say, somewhat in Gulf country, and the ship has to cross through the Indian waters, Indian territorial waters. So that person who is supposed to end his journey somewhere in the Gulf country, there is some litigations before the Indian court against him, and they have already issued summon against him that he must be brought before the court or he must show his presence before the court. And when that person is traveling and is not aware about those summons or the orders issued by the court. So when the ship is on voyage and it reaches the one of the Indian port and has halted, okay, the ship is at halt, that's like the transit period. So after that halt, after some time, the ship will again proceed its movement towards the Gulf country. So the question arises, now the ship has halted in the Indian port, so whether the court has the jurisdiction to give the copy of the summon or give the copy of that order to him while at the time he is on board or not. That's the point here. Now with regard to, as I stated, that in the civil law country it is possible. So if the court finds that he is sitting on the ship or he is on board the ship, and there is already a matter pending against him, matter of civil nature pending against him there in the court. So the Indian court does have the jurisdiction to give the copy of that notice or the order when he is simply in transit period. So that is what it says. In common law countries, which is based on the common law principle. In common law countries such as United States and Britain, the usual basis for jurisdiction in civil cases remains service of writ upon defendant within the country, even if the presence of the defendant is purely temporary. That is what it means by temporary, because he is on transit period and coincidental. Now, taking the case of the continental European countries like that of France and Germany and Italy, so they are mainly the continental European countries. There is not, that's not the case. In continental European countries, on the other hand, the usual ground for jurisdiction is habitual residence or domicile of the defendant in particular state. That means the person must, but that is based on the three criteria. One is either that person is citizen of that civil law country. Let's take the example of France. So either he is the resident citizen of that France, or it can be that he has habitual residence, that although he is a citizen of some other country, but he is very frequently visiting France and is staying there for some period of time during the year. Or he has obtained a status of domicile. The domicile status is when the person has a citizenship of another country, but he likes to live in some other country. So, and he likes to live in some other country, that means he intends to live in that country, and for that reason, he has lived there for a certain period of time also. So, in that case, he will be considered as domicile of the country of his choice. So, in all the three cases, the court has the jurisdiction to give him or any such issue notice against him or to issue the summons in the civil matters. So that is the distinction. So in case of the common law country, even if there is a temporary visit or coincidental visit, he can be given, there is a civil law jurisdiction is applicable on him, but that's not the case in the continental European countries. Then comes the rules applicable to warship and other government ships operated for non-commercial purposes. We were discussing mainly the commercial ships or the ships that are used as passenger carriers, all right, so that are used for the movement of people. Then there are the ships that are mainly used by the Navy persons or the warships. Now, they are also included under the UNICLAUS, that is United Nations Convention on Law of Sea. Article 29, definition of warships. For the purpose of this convention, warship means a ship belonging to the armed forces of the ship state, bearing the external marks distinguishing such ships of its nationality under the command of an officer duly commissioned by the government of the state, and whose name appears in the appropriate service list or its equivalent, and manned by a crew which is under regular armed forces discipline. That means at its outset, it should be visible that this is the ship of armed forces of that state, and then there must be a clear indication that who is the commander of that ship or who is leading that ship, and also the crew members that are with him. So that must be clearly listed. Mainly, there must be a symbolic representation that this is not the ship for the civil purposes, but exclusively for the army purposes, which should be apparent right at its outset. That means clearly visible on the hull of the ship, that is the body of the ship. So I repeat this: for the purpose of this convention, warship means the ship belonging to armed forces of a state, bearing the external marks. External marks, that means they are clearly visible outside the body of the ship or the hull of the ship, distinguishing such ships of its nationality under the command of an officer duly commissioned by the government of the state and whose name appears in appropriate service list or its equivalent. So it must be clearly listed that this and this person is holding this position in his country's armed forces, one of the armed forces, and then he must be carrying the relevant documents also, and manned by a crew which is under the regular armed forces. That means the armed forces discipline, but that means they are following the command given by their army leaders, or let's say the armed hierarchical orders. Article 30, non-compliance by warship and the laws and regulations of the coastal state. So the laws that are applicable to the ships for civil purposes, that is civil purposes here means the commercial liners and also those who are the passenger ships. So similarly, there are specific laws also for the warship, and those laws are recognized by the UNICLAUS also. Now, it's important for the UNICLAUS to cover those laws, reason being because of the mistrust between the nations. Sometimes there can be the genuine movement of the warships, and sometimes it could be with certain intentions. So that has to be distinguished very clearly, and there must be a law to safeguard the interest of all the coastal states. So therefore, they have covered the warship also. So if any warship does not comply with the laws and regulations of the coastal state concerning passage through the territorial sea and disregards any request for compliance therewith, which is made to it, the coastal state may require it to leave the territorial sea immediately. So that means once the warship intends to enter the territorial waters, so as per the law, they need to seek the permission. And they have to, usually it's the innocent passage they have to declare, but in case of the warship, they need to make it more specific that what kind of, whether they are carrying some arms and ammunition, for what reasons they want to enter the territorial waters. So after making all this declaration or after complying with all those conditions, they may be allowed to enter at the discretion of the coastal state. But if they are not willing to comply with these conditions that are set by the coastal states and are forcing themselves to enter into the territorial water area, so that can be something where the coastal state can write out, ask them to leave the territorial sea immediately, because that means there is some danger or there is some threat, or for what reason they are not following to comply with the laws of the coastal state. Next is Article 31, responsibility of the flag state for damage caused by the warships or other government ships operated for non-commercial purposes. As stated to earlier, what is the flag state? Flag state is the ship carrying the flag of that particular state. So that means all acts that are done by the ship, the law, or in most of the cases, let's say if not in all the cases, but in most of the cases, the law of the flag state will be applicable. But as stated to you earlier, that in some cases it can be the law of the coastal states are applicable depending upon the kind of breach that has been done by the ship. So that means there is some responsibility of the flag state with regard to its ship. So what are that? Responsibility of the flag state for damage caused by warship or other government ships operated for non-commercial purposes. The flag state shall bear international responsibility for any loss or damage to the coastal state resulting from non-compliance by the warship or other government ship operated for non-commercial purposes with the laws and regulations of the coastal state concerning passage through the territorial sea or with the provisions of the convention or other rules of international law. So at its beginning itself, the Article 31 has made it clear that it is primarily the responsibility of the flag state, where that ship is registered. And it is bound by international law. It is not that they are under the constitutional obligation, that is obligation set by their own constitution, but it is the responsibility created under international law that the flag state shall bear international responsibility. Now this responsibility based on international law means that is quite depending upon the will of the Committee of Nations, because the Committee of Nations here means countries globally intend to maintain peace and they want that the rights of the coastal state should be protected. So in the light of that, they have decided that such laws should be enacted to put the responsibility on the coastal state, or to what extent the responsibility on the flag state should be there. So here the flag state shall bear international responsibility for any loss or damage to the coastal state. If the ship has entered, foreign ship has entered the coastal state area and is not compliant. Now, what is the result of what is the cause of that damage? It's because of the non-compliance of any of the provisions either of the international law or of the coastal, the law of the coastal state. So in both the cases, they are supposed to meet the responsibilities. So what is like that? For any loss or damage to the coastal state resulting from non-compliance by either it's a warship or other government ship operated for non-commercial purposes. That means it's here since it's the matter of state responsibility. Now, in case the ship would have been owned by a private company, then the private company is liable, or the insurance company that are taking responsibility on behalf of the company, they are held liable. But if it is the government-owned ship or the warship, then who will be liable? The state will be liable. So warship or other government ship operated for non-commercial purposes with the laws and regulations of the coastal state. So either there is a breach of the law of the coastal state or international law, and for that reason there is a damage caused to the coastal state. Non-compliance for non-commercial purposes with the laws and regulations of the coastal state concerning passage through the territorial sea or with the provisions of this convention or other rules of international law. Article 32, immunities of warship and other government ships operated for non-commercial purposes. With such exceptions as are contained in subsection A and Article 30 and 31, nothing in this convention affects the immunities of warship and other government ships operated for non-commercial purposes. For some reasons, there are also the grounds of immunities to the warship and the government ship, and they remain unaffected when the provisions or the Article 30 and 31 is applicable. So, with such exceptions as are contained in subsection A and in Article 30 and 31, nothing in this convention, that is, convention here means unique laws, affects the immunities of warship and other government ships operated for non-commercial purposes. Next is the contiguous zone. The contiguous zone is the area that lies after the territorial sea. So again, that is for 12 nautical miles. So from baseline to territorial waters, it is usually I will use the term 12 nautical miles. Then again, from the territorial waters to further 12 nautical miles is the contiguous zone. Now, this areas of territorial waters or contiguous zone that can be reduced also, like for example, we have discussed the case of India and Bangladesh, then we have also discussed the case of India and Sri Lanka. So, there are chances of this deviation. But why we have this different zone? Because in case of the territorial waters, there is the sovereign rights extend, the sovereign rights or the sovereign claim, mainly the sovereign rights is the better term here. Sovereign rights extends up till the territorial waters. The same sovereign rights that a nation does have all across its land area will be extended up till the territorial waters. Now, with regard to the contiguous zone, the rights, they are also of sovereign nature, but they are not absolute in nature. So there are on certain areas only the state will have the sovereign right. It will not be absolute in nature, because those rights are created keeping in mind that there will be also the rights of the parties that are foreign to the coastal states, or they are the rights belonging to the other states. So, in order to make the proportionate balance between, on one side, the rights of the coastal state, that also based on the sovereign claims, and then the rights of the parties that are outside the coastal region, or that belong to the other countries, that has to be negotiated, or that has to be balanced. Now, here there is another difference, that primarily the rights are given, or the primary rights in most of the subjects or in most of the areas that belongs to that of the coastal state, and the secondary rights by and large belongs to that of the foreign state, or any state which is outside that coastal domain. So, in that respect, we try to set this mechanism, the legal mechanism, that there in majority of the instances, or in majority of the areas, or in majority of the subjects, those subjects which I am saying here, the majority of that, they are again listed under the unique laws. So, on what matters the coastal state will have the sovereign claims across this contiguous zone, and on what matters it will be the other land, or let's say the ship of the foreign country, they can make the claim. So, there is listing of those different areas. So, in that respect, we try to understand that what basically contiguous zone is, and how the laws that are applicable to the coastal state, they also apply to what extent to the contiguous zone. So, with this regard, I thank you very much for being party to this discussion, and I'm thankful for your participation in this discussion, and we continue further in this lecture on law of sea and maritime law. So, thank you very much.